Hey everyone, Walter Crosby with Helix Sales Development, your host of Sales and Cigars. Today's episode is a little out of character for us. I got out of character for two things. I got a lawyer on, which is normally not something I do, and two, I don't normally associate myself with lawyers. But JB is affectionately referred to as the patent baron. And the reason I think this is important for everybody to listen to as a business owner is that you have intellectual property in your business that you may not realize is intellectual property. So it goes beyond the stuff you have in your head. So if you're using an NDA with your employees or you're using an NDA with some of your vendors, there's something there that might need some IP protection. And we break down the difference between a trademark, a copyright, and registration, right? And what those mean and why you use them in different spots. And JB's was an engineer that went to law school, so he really understands and how to explain things. So he breaks it down real simple. So go grab a cigar, grab a cocktail, strap in for another educational episode of Sales and Cigars. Thanks. So JB, I appreciate you taking some time out of your busy schedule to jump on the podcast and have a conversation.
Well, happy to be here, Walter.
So we've known each other a little while, so I kind of have an advantage on when I do these. Most of the time, I haven't really talked to somebody, so it's always interesting for me to talk to somebody I've known for 5 or 6 years. And try to have a conversation that's meaningful. And it sometimes it's harder than it is to when I really don't know the person. But we're going to try to fight through that.
Okay.
Don't screw up.
No, sounds good.
So one of the questions that the audience likes, because it kind of gives them an idea of how your brain works.
Mm-hmm.
Is there a book that you reread, once a year? Is there a book that you gift to people? Is there any book that kind of has an impact on you?
Yeah, well, it's funny you ask that because I think you'll get a kick out of my answer. So it's a book I'm sure you're familiar with, but it is The Greatest Salesman in the World by Og Mandino. So it's an interesting book, to say the least. There you go.
This one?
That one. Yes. So I was certainly aware of it, and I rediscovered it, more recently, and been reading it, and I've recommended it to certainly several people within the last few months. I said, really need to read this. It's an interesting book. You have to look at it from, the perspective that it's being presented. But I think it's helped me, and it continues to help me. So that's, probably one you were maybe not expecting to hear.
It's one that I haven't heard before. I have a friend of mine who was working on writing it for children. So if you've read the book, you that would make sense, right? Because it's not just about sales, right? It's about the essence of sales. Like how do we become better at it? And it's really about helping people.
Right.
And the more we help people, the more opportunity we have in our own life. So if you can put that into a message for the kid, right? Mm-hmm. Whether they read it themselves when they get to that age, or it's a bedtime story where you read a scroll every night. I don't know that he's finished that or not, but I think that's a noble idea.
Yes.
Hopefully I just didn't give that away, that somebody else takes that idea and runs with it. But intellectual property, which we'll get to in a minute.
Yeah, true.
So you have to be kind of careful about doing that. I would imagine, but those principles are pretty standard. And you could spin that into a children's book pretty easily. And you started giving it to clients or to people you met in networking groups? How does that work?
Well, people that people I work with, and people that I have worked with, so attorneys, and I think I found it useful for me, and I don't know how if they take it to heart or if they actually do it, but I think it can help anyone, like you said. It's not really just for salespeople, as it were, and at any at some level, we're all providing a service, where we have to do something for others, whether you're an engineer or an accountant or a football player, you still are doing things, for others, and, you want to make yourself better.
As a human, right? Daniel Pink talks about that in his books. Essentially, we're all salespeople because we're all looking to um, share ideas, sell ideas, or we're part of an organization where we need to tell the story and live values and such. So, but I mean, I think it does speak to just being a solid human being,
Yes.
and doing doing the right things for the right reasons, when nobody's looking is kind of a real test. But we're getting too philosophical. Um, so, I know your background, and I think you got a cool story where you're, um, what you did in the past really informs what you do today. So why don't you walk us through, how you navigate, how you got to where you were? Because I would imagine when you were 10, you weren't thinking you were going to be an IP attorney, did you?
No, no, I wasn't really aware of intellectual property that much, except for things you might see in advertising or branding, like Coca-Cola or, registered U.S. Patent Office kind of things. But no, no, I started out, well, I'm a big car guy, as you know. So my general thought was to be involved in the auto industry at some level, and started my undergraduate program in mechanical engineering, although I had really thought about architecture too. But I got to thinking that there's just a lot more opportunities for engineers than architects. And luckily, the school I was attending, Lawrence Tech, in just outside Detroit in Southfield, Michigan, was had good engineering and architecture programs. So it was easy for me to just change my major and focus on engineering. And that transition, once I finished, into an automotive career, and I worked for a number of suppliers. And as we were talking earlier before we started the podcast, I was a contract engineer at Ford Motor Company for a short time.
So you went through I'm one of the few people who live in the Detroit area who has been able to avoid working for a supplier or an OEM, in the auto
Mm-hmm.
industry. And even tangentially, some of my clients will sell to people that sell to, but I've been able to avoid it myself. But so you walked towards the bright light, the fire.
Yes, yes. Well, again, a lot of it was from enthusiasm, coming from always liking cars and things, and then once you get involved in it, you see that it's a lot more complex, than it seems, and there's just certainly many levels and so forth, and that's really what led to my first real exposure to patents. When I was working at a supplier, I met their patent attorney, the department I was working in had developed some new equipment that they wanted to patent. And so I started thinking about that. I thought, oh, that's an interesting career because, I like to write, which is a little bit unusual for engineers. And one of my professors in undergrad suggested that I might want to go to law school too. So I had a few things kind of working on my mind there, and having the opportunity to work on other things and not be so tied to the auto industry, which, again, even the time that I was in it, I could see that it was a cyclical industry, and perhaps unfortunately, engineers, as they get older, oftentimes their experience isn't appreciated like it is in other professions, like medicine and law and aviation, to name a few. Uh,
Right.
Engineers can sometimes be, priced out of a position, and just based on that, and not on their experience. So I didn't want to be a kind of middle-aged engineer, in that situation looking for work. Whereas as a patent attorney, or even just as an attorney, I can have more work flexibility. I can work on my own, or work in a variety of organizations within, let's say, firms or a corporate counsel, and just have more career flexibility, not just even tied to the area. Although, I still live in Southeast Michigan, but to have that flexibility, to be able to practice pretty much anywhere is nice.
Yeah. So how long were you playing in the engineering world? Playing is trying to minimize it, but how long were you
Uh,
working in that space
yeah,
before you decided to go to
it was
law
about
school?
6 or 7 years, and I actually started law school in a part time while I was an engineer. So there was, I guess, maybe a little overlap at that point. But it got to the point where I needed to transition, and of course study for the bar exam and then the patent bar exam too. So there was a time when I stepped away, but it was there were some aspects too that were nice, because I was, had a good paying job with benefits and things, and that helped with, law school expenses
Sure.
and all of that.
Yeah, school's cheap. It doesn't
Right.
cost much. So, so the engineering thing, understanding how to read a drawing, understanding what goes into uh, the mechanics of engineering, helps you informs what you're doing when you're looking at certain types of patents, right? That are like you and I are working on
Mhm.
something. You're helping me with a trademark that is got nothing. There's no mechanical aspects to it, right? It's just the intellectual property. Um, but aside from those kinds of things, I would imagine having an engineering degree helps you, sort through somebody who's trying to take a product that actually has moving pieces or components.
Right, right. And I think, just from a bigger perspective, it's the problem solving approach. Engineers are problem solvers. And as attorneys, not just patent attorneys, but, that's what we're asked to do. We're asked to find solutions to problems. And whether it's a patent or a trademark or a civil dispute, I think engineering training has helped me in law school, and helped me analyze and be able to process and present information to individuals, to judges, to juries, about what the issues are, what needs to be resolved. So I think it's helpful. Most attorneys, don't go through engineering as a pre-law type of program. They choose other degree programs.
So it helps you be able to break down an argument to help
Mm-hmm.
explain a particular the nuance of a case, but breaking it down into component pieces so it's easier for dumb people like me to understand.
Well, right, yes, and don't sell yourself short, Walter. But yes, I think that's the challenge, that as attorneys, we, or even engineers, we can be so involved in a particular matter that we have our, it can be difficult to step back and say, how do you explain this to someone just walking in off the street who doesn't know what you know, and walk them through the elements of a claim, the elements of a case, what needs to be proven, has it been proven, and so forth. And, again, like breaking it up so that, again, kind of an instruction manual approach. And that's a good way to describe what a patent application is. It shows someone how to make and use the invention. And that's part of the bargain of a patent, is that you have to show the public how to make and use it, but you have exclusive rights as long as the patent's in effect. Afterwards, anyone can make and use it.
Yeah. So one of the things that we met at
Mm-hmm.
a networking group, and we've been in
Yes.
a couple of different networking groups together. But one of the things that occurred there was the day you were kind of doing the
Mm.
education component. Um, you broke down like I think this is something that most people, especially my audience, um, doesn't understand the difference of the registration, the registered, um,
Yeah,
and the TM, right? I mean, I'm just, if you're thinking about this, the R with the circle around
correct.
it and the TM. So can you use your breakdown engineering law school ideas to like explain the difference and then why they're
Sure.
appropriate
Yeah,
at certain
no
times?
problem. So I don't want to sound like a professor, but I'll go through it briefly so that it clears up any issues people have. So the circle R indicates a federal registration of a trademark at the United States Patent and Trademark Office, and that means it's gone through the entire examination process. It's gone through any opposition by others thinking that the mark was confusing, and it has passed all of those thresholds and allows you to have exclusive use of that mark in whatever classes it's registered in. And I think, as you've learned, there are 45 classes of goods and services, and there are people that have the same mark registered for other things. Delta is a great example. Delta Faucets, Delta Airlines, and so forth. So they each have it registered in different classes. You can, before you apply for a mark, and if you don't indicate anything, you can use the TM next to a mark to show that you're using a word, phrase, or logo, or a combination of those as a trademark, but that you either have registration pending or you're just using it as your trademark and you are just asserting the common law right of trademark on that particular configuration, whatever it happens to be. That is, it does give you some rights, but not nearly enough as federal registration does.
So it's a way to protect the use of it. So if I'm registering or if I'm trademarking the sales
Mm-hmm.
integrator, let's just say, um, that gives me protection in Oakland County, the state of Michigan, the United States, the planet, the
Well, at
universe.
least the United
Where does it
States.
protect?
So it would at least extend it there. So yes, and just take a step back. There are state trademarks. There are not state patents, but there are state trademarks, and even the state of Michigan and other states will issue them. It's something that certainly people have done in the past. I think more and more people are just bypassing that and seeking federal registration because of the internet and how it can reach people from coast to coast and beyond. It allows people to have a single location, but attract customers throughout the world, but certainly within the U.S. Now, you can seek international trademark protection, and that involves going into different countries and following their procedures. So it can get quite complicated beyond that. But you can also bring a foreign trademark into the U.S., for example, and say it's been used in Italy for a number of years, and then you can seek to register it in the U.S. So that can be another approach, but just to kind of keep things a bit simplified for the sake of the discussion, we'll focus on the U.S. And it does allow you to, and I was just going through a webinar recently where that was restated, but how the U.S. Customs and Border Protection you can use those services to protect your trademark to prevent infringing goods from coming into the U.S. And there's all sorts of equipment that the government has to help you with that. But that is something that can really help, particularly when you're talking about goods, not so much with services, but particularly with goods.
Okay, so that's helpful, and I think that's informative to those of us who are like, what's the difference, and you sort of broke it down that so that
Right.
we understand that. So if you're a business owner, and I don't know, you could be a manufacturer, you could be a distributor of other people's products, it could be some sort of an agency that that has a particular process that you're using. So the point I want to make, and I'm going to lean on you to help how we talk about it, but what should the business owner be thinking about that they have intellectual property that they might not realize? So how do they figure out if they have something? Take their
Mm-hmm.
logo off the table for a second, right? That um, you know that's pretty straightforward. They should protect
Right.
that if they can. But what other types of like engineering processes or service process, if you're
Mm-hmm.
a marketing company, if you're a provider of some engineering service, what might they have that is worth having a conversation with somebody like you? This, should I
Right, right.
protect
Well,
it?
I think the big question you can ask yourself is this something that you would want your competitors to have? And if the answer is yes,
Hmm.
then there's a good possibility, you know, you don't want them to have it, that it is intellectual property. And that can extend to, like, say, trade secrets would be a good example of that. That can be procedures and customer lists and other things, know-how, things that you've learned or your business has learned that makes your company perform better, gives them an edge. And that's why you can seek to protect that with non-disclosure agreements with your employees and your contractors and so forth, because you don't want someone to leave your business and then open up a competing business and take all of that information that might not fit into the box of a patent or a trademark
So
or even
if
a
you're using
copyright.
an
It might
NDA
not. It might
around
touch
it,
on those.
yeah.
Oh, sorry. Go ahead.
So if somebody's using, yeah, if somebody's using an NDA, that might be an indication that there's some value there that they should
Right.
contemplate
Right. I think it's a
protecting.
red flag, or at least brings note to something that, okay, this is a more serious thing. Whether you're talking to a potential supplier or subcontractor, someone you're partnering with on a joint venture, things like that. Non-disclosure agreements are really a good thing to have. But as I was just advising a client yesterday, I certainly would seek to protect it with patents, trademarks, copyrights, and whatever fits into that situation in along with a non-disclosure agreement, if possible. If you're developing a prototype, for example, you would want to think about filing a provisional patent application at the very least before you turn over those drawings, CAD, and so forth to a prototype manufacturer, and then have them sign an NDA as well, because then they're on notice that this is a patent pending product, but also you have the non-disclosure agreement to reinforce that. Because again, the goal would be to get that patent approved and granted, so that you would have those legal rights in addition to the rights that the non-disclosure agreement, if it were violated, would offer you. Right.
Some protection. So if it's not a widget, if it's not a
Mm-hmm.
thing that you're building or prototyping, and you have a particular way of helping a client, and there's multiple steps, and you call it something,
Mm-hmm.
and you always do it the same way, is that intellectual property that's worth
Well, I think so, and
protecting?
just to expand on the widget, analogy, methods are something that can be patentable. It's hard to say if a particular method of, let's say, sales training and so forth, might be patentable that way, but there are methods, for example, on how to make a particular composition, let's say a chemical composition of mixing a variety of chemicals in certain ratios and heating or otherwise processing them to get a certain end product. So it's not just restricted to widgets, but to add to what you were saying, it could be something that would fall into a trade secret. It could be something that could be included in copywritten material, so that if it were reproduced by someone, let's say they removed your letterhead and put their letterhead on it, but you can show that the contents are essentially the same. There could be copyright violations. So there are other, I wouldn't say it's a one size fits all situation, but you can use certain elements of intellectual property to help protect pretty much any idea.
So it's worth thinking about if you have a process, a methodology that you use that is consistent and provides a specific result. It's worth having a conversation to determine if it is something to protect.
Mhm.
And you just mentioned something else though.
Yeah,
The C with
copyright.
the
Yes.
circle around it, right? The copyright. Is that how is that different than the TM other than the
Right,
fact that
right.
it's
So
a
a
circle with a
trademark
C?
identifies the source of a good or service. So if you're looking at, let's go back to, I think we mentioned Coca Cola, but I always use Coca Cola as an example. But when you pick up a can of Coca Cola, you have a very good confidence that that's an authentic Coca Cola product. And maybe it's hard to imagine, but certainly in other countries, this is more of a problem with counterfeit goods. So you could pick up a can that looks like a Coca Cola can that maybe feels very similar, but it's not bottled by a licensed Coca Cola bottler in that country. And I think you may recall or scenes where people have something that's very similar to McDonald's in other countries, but it's not McDonald's. So we're in this country we don't have to, I guess, navigate that as in other countries because of the strength of our IP laws. But trademarks protect, again, the source of a good or service, so that that that's an authentic Coca-Cola product, a Nike shoe, and so forth. Whereas copyrights protect original works. And I just saw a news story about, I think Mr. Musk was getting into some issues with his recent robo-taxi introduction and some Blade Runner materials and things. So there's a brewing IP battle there. so any original work could be a movie, in this case Blade Runner. It could be a sculpture, a photograph. A lot of people get into trouble with grabbing photos off the internet and not seeing if they are copywritten. Sometimes they're free, but you have to look, and that depends how you're using them too. If you're using it for educational purposes, you could argue fair use. But if you're using it as a commercial, part of your commercial activity, then you don't have that protection. So, um,
And there's plenty of
oh, sure,
services out there
Getty
just for
Images, and
photographs, right? That
right,
you
there are plenty of
get
them, and
stock
it's really,
photos.
as
Yeah,
people are searching through trying to find something for a newsletter or whatever the case may be, they can get in a lot of trouble if they don't investigate that. But if you go out and you take a picture of fall scene at this time of year and put it on your website, you took that photo, it's on your computer, you can prove when it was taken, you're the original artist, so it's free for you to use it.
and even if you cite who give credit to the, in certain cases, you still get in trouble
You
for
can, if
using
it's
their
a
work
commercial use, you could
properly.
still get into trouble. If it's, I would say, a professor, using a photo of something to illustrate something to students, or really in a educational, whether it's a non-commercial aspect, that's the thing. And it's good to err on the side of caution and not get in. There are places, like you said, where you can get stock photos that are free, or you can sign up, or if you have permission, you can go through other Getty and other agencies to have an account where you can use them. But of course, there are costs involved.
Sure. Yeah, and even the stock photos, to get the free ones. I mean, I use a service that provides me
Mm-hmm.
lots of access to uh, photos that don't
Right.
have a restriction on them, but I pay for the access. Plus, you have
Yes.
the AI component of that. So, um, I think there's a. I think we broke down the basics. I think we broke down um, the reasons why. Right? There's if even if you're not sure, it's worth having a consult with you to talk about what you need to do to protect it, if it's worth taking the time and effort to do it,
Mm-hmm.
what the upside, what the downside is. And I, I think so that you've shared those issues. What's the best way? We're going to have your contact information in the show notes, but where would you direct them to say, hey, JB, I want to reach out. I have a
Sure.
question
Well,
about
I do have a
what's the best way to do
website.
that.
It's patentbaron.com. So that's a place where you can learn more about me and my experience. And there's contact information there. So you can reach out to me through the website or you can give me a call. All that information there. And that's probably the best way to reach out to me. And then you can set up a consultation and talk about, how to put a lock in your ideas is, part of my tagline.
Yeah, I like that. I like any idea. So I would really encourage you if you even if you think about if you're doing NDAs and if you're worried about your competition having, I think that's a really good distinction. You really wouldn't want your
Right.
competition to have a look under the hood of the thing that you're talking about. That might be worth protecting, and you might not be able to do it, but there might be a way to reposition it or make some modifications to put it in a better light to give you some protection. And it's not really expensive to take the precaution um, to to put yourself in a better spot. So I would encourage you to reach out to the patent baron here, JP. Um, it, so my last question is always the same, JB. Any relationship, past or
Well,
present,
nothing in
with
the present. I do recall my grandfather. I think would smoke a cigar from time to time. So I do have that memory of it. So, and yeah, I think I knew you kind of prepped me for that question. So, but yeah, I think that's kind of I can visualize him. Dressed up as most people were, years ago in old photos and things, and having a cigar and things. So that kind of fit with his, um, you know, my memories of him.
it, there's been a few guests who've talked about the grandfather or the uncle, um, where the cigar is sort of like
Mm-hmm.
that.
Mm-hmm.
You smell it and it takes you back to that person, that moment. And smell is really the thing that can
Yeah.
immediately that sense pulls you back
Yes,
someplace,
I agree.
snaps you back really fast. Um, and the smell of cigars is somewhat unique. I can say this: I was once walking. My wife and I'll go for a walk, and Heidi. We'll go for a walk, and I usually take a cigar and you know try to make sure the smoke's not blowing in her face. But we were out one day, and she's like, that
Mm,
cigar smells different, and I'm like, how so? And she's like, well, it smells like my grandfather's cigars when we would
okay.
go for a walk in the woods in Germany. And I said, well, did your grandfather smoke Cuban cigars? Because that's what this is. Um, and what blew me away was because we talked through it, and it was probably a Cuban that her grandfather smoked because they were in Germany in the
Mm-hmm.
70s. But she could tell the difference from pedestrian or like I smoke Padrones on a regular. Like that's uh, a the store you can buy anywhere. It's really consistent. But she could smell the difference between that and the Cuban cigar, which to me, if anybody ever is wondering whether or not there's a real difference,
It's
there
a
it
good
is.
story. I like
Because my
that.
wife could smell the difference. Yeah. So I appreciate you taking the time. If you got any kind of questions around patents or intellectual property, I really recommend giving JB a call. He's happy to help you through the process. It's it's a lot of dotting i's and crossing t's and putting things in the right boxes, but it's
Happy
not
to help.
something I want to do. But
Yes, happy to help with that.
that's why the engineering in the law school helps. All
You're
right, man.
welcome.
Thank
Thank you,
you.
Walter.
Appreciate it.